Welcome to the Nichols Tax Update podcast for April 26th, 2021, issue 21-17. This program is produced to provide current information about developments in United States tax law, cases, rulings, IRS pronouncements, and expert comments on hot topics. You are receiving it as a member benefit from the South Carolina Association of CPAs. My commentary is necessarily brief, and you should consult appropriate authority before taking a position on any item discussed in the program. I wish to acknowledge the value in preparation of this program of my subscription to Tax Notes Today. I frequently quote Tax Notes Today. Tax Notes Today is published by tax analysts, in my view, the preeminent source of information for tax professionals. What's in this edition? 5 items this week, although we had 6. If you get the citation list for this week, there is one article that I was particularly attracted to on the issue of a shareholder's contributed note to an S corporation establishing basis. Get the Word document that accompanies this program, and or send me an email and I'll send you the citation. In any event, we have a refund claim denied for just simply failure to sign a return. IRS is focusing on exempt organizations, and if you do any work for exempt organizations, you need to know what they're focusing on and what you need to be alert and ready for. A foreign bank account report challenge fails again. A $3 million penalty is not excessive. This was family money, according to the taxpayer that was caught up in this failure to follow the instructions. Tax credits for paid leave for COVID-19 vacations are available, and we'll tell you how to apply for those and how to claim the credit. And finally, there is a safe harbor for deducting expenses that are paid with original PPP loans. That's been up in the air, as I'm sure you know. We could deduct the expenses, then we couldn't deduct the expenses, then we could deduct the expenses. Now I think we have the final word. So, a refund claim is denied for failure to sign a return. Andrew Matson. Various documents, including the Form 2848 itself, a power of attorney, and an amended Form 1040 signed by an attorney or employee of the attorney without evidence of authority to do so, did not establish a signed return. So it's an unsigned return. It cannot even be an informal claim for refund because the taxpayers brought suit before they perfected the lack of signature. So you had an administrative issue. This is, I looked all this stuff up. The CPA involved with all this is a guy named Castro. And just reading between the lines, it looks like Mr. Castro solicited a group of Raytheon employees and he led them to believe that they could rescind their closing agreement regarding their their Section 911 foreign earned income deduction, and avoid both Australian income taxes and U.S. income taxes. Well, that's a wonderful idea, but it just didn't work. Attorney Castro, John Castro, is the guy that said all of these. So you can take a look at Dixon, and then there are some other cases cited in both Matson and Dixon. This looks like a situation where an attorney overstepped his oversold his ability to deal with some of the technicalities of filing a claim for refund with the Internal Revenue Service. IRS is focusing on exempt organizations. Here are a couple of energetic volunteers. As I mentioned in the first part of this program, I frequently quote Tax Notes Today. This is one of those times. This is an article by Fred Stokeld, who covered a conference where an IRS executive made these remarks. As of March 1st, the IRS had closed 1,065 exempt organization examinations for fiscal 2021. There has been an 86% change rate on closed compliance strategy exams, the most common issues in those being self-dealing and filing requirements. The change rate on data-driven exams, information from returns and casework, is 88%, slightly higher. And finally, a 79% change rate on a total of 579 exams that were undertaken based on referrals. The most common issues in all of these change cases are the filing requirements, unrelated business income, excise taxes, organization requirements, that is, you got to be properly organized as an exempt org, and employee classification, and I think that probably runs to properly determining whether an employee is an independent contractor, whether a worker is an independent contractor or an employee, and with the issues about employment tax. I would not be surprised if that's not what employee classification means. Next, a foreign bank account report challenge fails again and again and again. And if you are not a soccer fan, that's a red card, and that means you're done for the day. You're out of here. Get off the pitch. The government got summary judgment against an individual suit challenging a $3 million penalty for failure to file a foreign bank account report regarding his interest in a Swiss account. Leon Landa very clearly dealt with the money as though it was all his. He withdrew the money from one bank, he put it in another bank, he checked on it about every 6 months. Actually flew to Switzerland to look after the money. He claims it's family money, but he was clearly trying to hide it from the Internal Revenue Service. The penalty was not wrongfully assessed here because he had a financial interest in the account. He had signature authority. He clearly had a financial interest. It was not an excessive fine under the 8th Amendment. The court was sympathetic to the family history of protecting the wealth first from the Nazis and then the communists, but was compelled to follow the statute imposing the penalty. The dicta, the conversation, what the judge wrote that he didn't have to write to get to an opinion, explaining the reasoning for the opinion, includes some comments on willfulness and punitive charges versus remedial charges. I've got some cases here at the bottom of the slides you can refer to if you're in this issue. Norman, Kimball, Kennedy versus Mendoza-Martinez. All of these are referenced in the Landa decision. But I commend the Landa decision to you if you are concerned about a client's failure to file the foreign bank account report and asking yourselves the question, what do we do now? Landa decision gives you some guidance on what you might want to do to minimize the damage. Tax credits for paid leave for COVID-19 vaccinations. Refundable tax credits are available to eligible employers that pay sick and or family leave between April 1st, 2021 and September 30th, 2021. An eligible employer is any business, including a tax-exempt organization with fewer than 500 employees. The credit can be claimed for paid sick leave and for family leave. Now, those are two types of leave, as you'll see when we get to the next slide, and that reduces the employer's share of Medicare tax. So let's go to the next slide. These two credits, the tax credit for paid sick leave wages is equal to the sick leave wages paid for COVID-19 related reasons for up to 2 weeks, 80 hours, limited to $511 per day and $5,110 in the aggregate at 100% of the employee's regular rate of pay. So the employee is sick, he's off sick due to COVID. You've got 2 weeks, 80 hours of paid sick leave wages available for the credit. The tax credit for paid family leave wages is equal to the family leave wages paid for up to 12 weeks, limited to $200 per day and $12,000 in the aggregate at 2/3 of the employee's regular rate of pay. Those are substantial credits, and you don't want to miss them if you have an opportunity to claim them. The sick leave credit, for example, if the employee goes to get the vaccine and they're gone half a day and you pay them half a day, or you pay them for a full day, you can claim sick leave wages for that. If they have a reaction to the vaccine and they have to take a couple of days off, and you pay them their regular rate of pay, you can claim the paid sick leave wages for that. Eligible employers report their total paid sick leave and family leave wages, plus the eligible health plan expenses and any collectively bargained contributions, and the eligible employer's share of Social Security and Medicare taxes on the paid leave wages. You report all of that for each quarter on their federal employment tax return, Form 941. Next, a safe harbor for deducting expenses paid with PPP loans. In case you haven't figured it out, that's a King's X, safe harbor, right? Revenue Procedure 2021-20. Eligible employers can officially deduct original Paycheck Protection Program loan expenses. See the asterisk? Go down to the bottom. A loan expense is an expense paid with PP loan proceeds. Or you can officially deduct those under this revenue procedure, allowing them to claim the expenses on the subsequent year's tax return. So you got a PPP loan in 2020. At the end of 2020, there was a lot of uncertainty as to whether you could claim a deduction for those expenses you paid with the loan, or whether you could not claim a deduction. And some people claimed a deduction for the expenses that were paid with the loan proceeds. Now we know you don't have to do that. So the legal premise that was underlying the reasoning in Revenue Procedure 2020-51 is no longer correct. And section 0.04 of Revenue Procedure 2021-20 explains the time and the manner for making an election to apply the safe harbor. Requirements for the statement to be attached to the return are clearly explained and listed in paragraph 2 of section 4. Require the name and address of the taxpayer, the amount and the date of the original PPP loan disbursement, and a list of eligible expenses paid with the PPP loan proceeds. I think that we're at the end of the game for this week. It's always great fun to look for things that I'm interested in, that I think maybe you might be interested in too. So that's a wrap for this week. Thank you. And remember, stay safe, take care of yourself. We need all of us to get through this together.